as the chair of the Singapore International Arbitration Center's Users Council Committee for Africa, and is also a member of the Singapore International Arbitration Center's Users Council Executive Committee. And last on our list of panelists today is the moderator for the day, and that is Dr. Ademola Bamgbose. He's an international arbitration and litigation lawyer in the London office of Organ and Lovells. He's a key member of the firm's global Africa practice, and is admitted to practice law in Nigeria, England, and Wales. They represent clients in high-value international disputes and advises clients on issues spanning multi-sectors and jurisdictions, especially in Africa. His PhD thesis, completed with distinction at the University of Warwick, focused on the arbitration framework for 19 African countries. He's an honorary lecturer and a visiting lecturer also at the University of Ibadan, as well as the University of respectively. Dr. Bamgbose is also a co-founder of the Africa Arbitration, director of the Africa Arbitration Academy, and regional representative Africa of the London Court of International Arbitration, Young International Arbitration Group. So we have a packed panel, and if you want more about the bio of our panelists today, you can go over up. And of course, they have information on the internet. I will hand over to Dr. Bamgbose now to take it from here.
Thank you so much for the introduction, Tolu. And good afternoon, everyone, and welcome to the second session of the conference. Before going on, I should thank the YNG team led by Efosa Ewere and Folake Sodiq for this invitation and for their good work leading the YMG team. This afternoon, we are going to be discussing, some of the key themes in ISDS, as well as some of the opportunities open to young practitioners, interested in doing work in ISDS. Like Tolu rightly mentioned, I'm joined by a distinguished panel made up of some of the brightest young and successful practitioners in the ISDS space, not only in Africa, but across the globe. I've had the opportunity to work and interact with these panel members or listen to them speak in one capacity or the other. And I can tell you for free that we are in for an enriching session. Please take advantage of the session and send in your questions. I can see the panel members are looking very calm. So please send in very, very difficult questions. Let's try and make them sweat a bit. Anyway, we have a good number of questions to go through in so short a while. So I would make a start. And Guled, I would start with you. Let's go back to the basics. ISDS is a very popular acronym in international arbitration. Could you please kick off this discussion by telling us what it stands for, what the mechanism was designed to achieve, and if you could also highlight any key differences between the mechanism and commercial arbitration, that would be very great. Over to you, Guled.
Thank you, Ademola. I thought your question was going to end with explaining what ISDS stands for, and that would have been a very easy one. So before I start with that, I just want to thank Ifos and all the other organizers at YMG for inviting me and for putting together such an excellent event. So what investor-state dispute settlement, I think the easiest way to explain it is if we look at it through a historical lens, and if you'll excuse me, perhaps a bit of a political one as well, to put it into context. So really starting in the 60s, 70s, what you came across were bilateral investment treaties that were entered into between two states. Those bilateral investment treaties, let's say, for example, between Nigeria and Peru, would provide that both countries would ensure certain levels of treatment to each other's nationals. So for example, if a Nigerian investor invested in Peru, they would be ensured that if they developed a factory there and that factory were nationalized, that it would be nationalized in a non-discriminatory manner, that they would be given prompt and adequate compensation. And if any of those standards were breached, then the Nigerian investor could bring an investment treaty claim against Peru in order to seek compensation and to establish that there was a breach of the treaty. So the very interesting thing about these treaties was that there was a bit of an interesting triangular relationship, because unlike commercial arbitration, where it's typically two companies that enter into an arbitration agreement and then have a dispute afterwards, the treaties themselves were entered into between two countries, and they granted an investor, the national, the right to bring a claim against the host state where they invested. So the national, the investor themselves, is not a party to the investment treaty, but they get benefits and rights that flow from that bilateral investment treaty. And so, in the 80s and 90s, there was a proliferation of these bilateral investment treaties. And when ICSID, the International Center for the Settlement of Investment Disputes, which falls within the World Bank group, was established, there was a discussion about the purpose behind investor-state dispute settlement. And I think a very prominent Nigerian jurist put it best. Taslim Elias, who was Attorney General, Chief Justice of Nigeria, Judge and President of the International Court of Justice, was Nigeria's representative at the convention, where the ICSID convention was drafted, negotiated, and finalized. And the way that he explained bilateral investment treaties and investment arbitration was that, in effect, there was a real bargain at stake, meaning that developing countries were entering into these bilateral investment treaties to grant protections to what were generally investors from developed countries. And in return, there was a promise, in effect, that there would be more foreign direct investment. The notion was essentially that foreign investors would feel more comfortable having disputes with foreign governments resolved in a neutral territory, rather than an environment where sort of developing countries would have home court advantage, so to speak. So really, it's developed and gone from strength to strength. And ICSID, almost without fail each year in the past 5 years, 10 years, has had an increasing number of cases registered there. And the center deals with the majority, administers the majority of investment treaty disputes. So really, that's the subject matter that we're looking at today, these really distinct disputes where an investor, through a mechanism established by two countries, two sovereigns, is able to bring a claim directly against the state that it has invested in as a result of an alleged breach of the standards that are found in the bilateral investment treaty. The interesting thing about these bilateral investment treaties is that they're only around 10, 12 pages. They're quite standard. And the language in there is rather ambiguous. So, for example, a common provision that is hotly debated in these cases is that of fair and equitable treatment. And lawyers in the field have a tendency to always argue fair and equitable treatment because its meaning and its context sometimes can be in the eye of the beholder, so to speak. And a lot of different standards of treatment have been sort of implied within the meaning of fair and equitable treatment. So it's an area that's really been growing quite rapidly over the past 20 years or so. But one issue that we'll come across in the course of today's discussion is that there's been something called a bit of a legitimacy crisis that's come out of investor-state dispute settlement. There are two tiers of concern. One of them is that the system allows foreign investors to challenge measures taken by a government that have gone through the ordinary process domestically. So a measure that's been adopted through the democratic process is being challenged by a foreign investor. That's one issue. Another issue that's come up a lot is the size of the awards that come out of these disputes. Obviously, these are claims that go to large investments that are often worth billions. And the average amount awarded to a claimant in investment arbitration, if they are successful, is around $400 million US. And so this perceived intrusion into national sovereignty and the size of the awards are the biggest concerns that people have had. Then there are other concerns as well, namely transparency. For example, a lot of these disputes, the awards are published, but that's not the rule by default. Another issue is the diversity of the arbitrators, typically a panel of 3 lawyers, academics, former judges, who decide these disputes. They have a tendency to not be very diverse, geographically representative. There isn't much gender diversity. And the other issue, of course, is that there's this notion of double hatting, meaning that one week somebody acts as a counsel in investor-state disputes, and then the next week they're acting as an arbitrator, which raises the concern that as an arbitrator, they may be taking decisions to lend credence to their client's case where they're acting for an investor. So those are some of the issues in the sphere. And so although it is rather sort of nascent in the early stages, investor-state dispute settlement, we already see a desire to change it. And there are two schools of thought on that. There are the revolutionaries who want to abandon the system completely. And then there are the reformers who want to revise it. And at the moment, ICSID is revising its arbitration rules in order to address some of the concerns around transparency, efficiency, etc. And at the same time, UNCITRAL is proposing reform of the investor-state dispute settlement system. And they're having discussions about a potential multilateral investment court, because most of these disputes are resolved by ad hoc tribunals, which are set up for the specific purpose of a given case. So some of these themes will come up in today's discussion, but hopefully that gives everybody an idea of the fundamentals of what investment arbitration is, what is at stake, and the state of play at the moment.
Thank you so much, Guled. It's amazing how I thought you would sweat a bit in the process of answering that, but you treated that like a real boss. Well, I'll come back to you. We'll see if we can make you sweat. Leah, let's go to you. Guled made reference to ICSID, and I have a couple of questions for you in relation to ICSID, but let me ask you a minor question at this point. Can you tell us what ICSID is and what its mandate is within the ISDS framework?
Okay, thank you very much, Ademola, and many thanks to everyone who's on the panel. I think I know everyone. I've worked with Maryan before, and it's indeed a pleasure to be with you this morning. It's morning for me here in Washington, DC. And thank you to the organizers, EFOSA and Folake, for inviting me. To start us off, I wanted to just start with a basic introduction of what ICSID is. Guled did mention, he defined for us very beautifully what ISDS is. And ICSID is one of the institutions that ISDS cases come to. So ICSID is one of the 5 organizations that make up the World Bank Group. Its mandate is to provide an impartial and effective international forum for the resolution of disputes between host governments and foreign investors. So the base convention for establishing ICSID is the ICSID Convention itself, which was established in 1966. And just to point out who our members are, we have 155 members, 46 of which come from the African continent. Djibouti is actually our latest, our newest member to join ICSID, and on June 9th this year. So we're so proud of that, especially for me, that it's an African country. And just while we're on that topic, I might just digress a little here and talk about the important role that African states have played in shaping ISDS the way we know it now. So African states were actually the very first states to ratify the convention. 15 out of the 20 first signatories were African states. So, and then secondly, African states have actually contributed immensely in terms of ICSID arbitration practice. I'm sure some of you who practice in this field have heard of Salini, the famous case that the tribunal first set out an objective criteria for what is an investment. So there have been very many fasts for Africa. For example, the first ever registered case was Holiday Inn versus Morocco in 1972. And the first conciliation case, the first case to do this. So there are many, many fasts. Even the first case actually to undergo an annulment decision was against an African state. So you see that African states have actually formed a big part and a big role of ICSID, how ICSID is. And so I'll just move on from that part to, from an organizational perspective, big picture, what is ICSID made up of? So ICSID has an administrative council and a secretariat. So the secretariat, which is headed by our Secretary General, carries out the day-to-day work of ICSID, while the administrative council, which is headed up by the president of the World Bank, who's currently is David Malpass, that plays the governance role. So we are organized into teams which administer pending cases. So a large bulk of our work is to administer cases. We also have an institutional arm that carries out institutional projects, which I'll talk about in a few minutes. And we also have our finance and administrative team. So ICSID administers arbitration and conciliation cases under the convention and ICSID additional facility rules. However, most people actually don't know this, but and Guled said it, but ICSID also administers ISDS proceedings under other sets of rules, such as antitrust. We also act as an appointing authority, and we've done so for a number of FTAs and BITs. We've actually been named as an appointing authority. And we also have very active publications in the area of foreign investment law and ISDS. So here I'll just pause and mention that we recently issued a special issue on Africa, which is available for free on our website. And this is the first time that ICSID has dedicated an entire journal to Africa. It's been authored. There are a number of articles authored by very prominent academics in Africa. We have Dr. Mohammed. We have, Makan, Professor Makan. So the names are escaping me, but I'll remember them and then put them in the chat. We have Professor Makan. So all those, that special issue can be downloaded for free from our website. So that's it for me on an introduction of ICSID.
Thank you so much. Thank you so much, Leah, for that. Jackwell, let's go over to you. Let's virtually travel down to South Africa. Guled made reference to BITs. And as we all know, ISDS agreements are commonly found in treaties, BITs, just like we would usually find commercial arbitration agreements in contracts, usually. So, Jackwell, what are some of the common substantive protections that we would usually find in BITs and treaties, the breach of which could give rise to an ISDS claim?
Thank you, Ademola. When we have regard to, so everyone, as Guled has given some context to essentially what ISDS is. ISDS, or investor state arbitration flows from a treaty. And in the treaty, ultimately for an investor to initiate a dispute against a state, there must be a basis for that. The basis for that is usually found in the treaty, and those are in relation to the guarantees that a host state has given to an investor in that particular state by virtue of either multilateral investment treaty, by virtue of a bilateral investment treaty, or sometimes investment agreements, so concessions, joint operating agreements, and so on. Now, the substantive guarantees that you normally find in these type of instruments are, and the common ones are, guarantee against unlawful expropriation, expropriation without compensation, fair and equitable treatment guarantee, national treatment, most favored nation. And the most common ones that are usually found in most, or are usually relied on by investors, are the fair and equitable treatment principle or guarantee, and the guarantee against unlawful expropriation or expropriation. Now, if we unpack these principles, so what does fair and equitable treatment principle, or the fair and equitable treatment principle essentially entail? It's a treatment standard, which is very vaguely set out in investment treaties, or not really set, it's merely a statement made that a host government, and I'm paraphrasing, will provide fair and equitable treatment to the investment of an investor. And for that, obviously, again, you need to look at, firstly, are you a qualifying investor? And then is there a qualifying investment to rely on the substantive grounds for alleging a violation? Now, fair and equitable treatment is a very controversial concept. And when you look at African instruments, so all the old generation treaties, whether you look at South Africa, whether you look at any other African state, has the concept fair and equitable treatment. But if you look at the development over the past few years in relation to the uncertainty around what is fair and equitable treatment, so tribunals have tried to, over years, tried to dissect essentially what is contemplated by this phrase, fair and equitable treatment. So when you have regard to that, you'll see that there's a debate of whether it forms part of the minimum standard of treatment, which is the customary international law standard, or whether it's a separate standard. But what has come out over, and again, if you have regard to the tribunal decisions, there's reference to a legitimate expectation. So as the state created some form of legitimate expectation with the investor in the form of promises, assurances that come, and I'm making an example of granting a license for a power concession to generate power in a particular state, and say that I will ensure that the regulatory framework is kept stable for a particular period of time. So the question is, if there's a violation of the assurances that the state has given to that particular investor of that particular investment, whether that would be tantamount to a breach of the fair and equitable treatment principle. So it's a very complex, evolved concept, and that's why a lot of African states, if you look at the development of the concept in Africa, you look at the Pan-African Investment Code, which is a draft code, it's actually omitted. It's totally omitted. If you look at the South African position on fair and equitable treatment, that concept has evolved from a fair and equitable concept to a fair administrative treatment concept, which is more a domestic level, and that has folded into a multilateral investment arrangement, where in the SADC model BIT, there's also an omission of the FET standard and an adoption or proposed adoption of the so-called FAT standard because of the difficulty with FET. And in the SADC protocol on finance investment, that has also been omitted. So that FET, and I think it's part of the discussion here, it's very difficult to explain it in totality because it's a very involved and cumbersome concept. So the other standard of treatment, I'm not going to go into most favored nation and national treatment, is expropriation. So you can get direct expropriation, where essentially the state expropriates asset or takes control physically in terms of the ownership of that asset. So I own the mine, the state takes over the title of the mine. So that's actually taking over ownership. Indirect expropriation, where through measures, an investor essentially loses his title to the investment. So there's not actual physical loss of the title, but through measures, there's a loss of title. So those are also types of standards of conduct that are guaranteed or protected in investment treaties, where states conduct or measures result in a investor ultimately losing the entire investment, or there's a complete loss of the investment. So I think in a nutshell, that covers some of the substantive standards. It's not possible to discuss all of them in detail, but in essence, that is the standard. Thank you.
Thank you so much, Jackwell. I mean, I know, to be honest, I know that I've not been fair to you with the limited time that I've given you, but we would have time to discuss South Africa in more detail later on in this session, because I think you've had a very interesting experience, especially a couple of years ago. So we'll discuss South Africa in hopefully if we have time. My next question is for you, Maryan, and I'm going to be drawing a bit from your previous experience working as chief legal advisor to the Prime Minister in Somalia. Listening to everyone speak, it's almost as if ISDS was designed to protect, the interest of investors. Why do states, particularly African states, continue to enter into BITs? Maryan, over to you.
Thank you so much. And thank you to the organizers and for inviting us. It's my hope that next year we'll be able to be in person in Nigeria together. So I think with your question, if I can just give a comparison, I think it's good for us to talk about ICSID, because ICSID is, I wouldn't say the most popular, but it is the most popular forum for parties, and it is heavily mentioned in bilateral investment treaties as the ISDS forum in the provision. So if we could compare, like, for example, the CISG, which undoubtedly is, considered one of the most successful commercial conventions, which is the Convention on the International Sale of Goods. If you look at the map, you can see there's hardly any African state parties to this convention, right? But with ICSID, African, exactly like Leah said, African states are heavily involved, and they have been heavily involved. In Somalia's case, I think Somalia ratified the convention in 1969. There was delegation there. They had numerous translators, and of course it was, at the World Bank. And so the CISG, and the reason why I'm giving this comparison, I remember when I did research on the CISG, there were hardly any translators. And there were even delegates from, I think, like Senegal and other countries who just sat there and couldn't understand anything that was going on. And so I think the early sort of history, looking at successful conventions and such, it's really important to note the difference between ICSID and the level of involvement that it had with African states. I think even though it was, more than 50 years ago, we're still seeing, I think, the positive outcomes of the early roots of how ICSID came about. If we can talk about the role of BITs, it's going back to what Guled said. I think so many great points have already been made, but a lot of developed states were going into BITs with, I wouldn't say less economically developed, but in Africa's case, like for example, my country, Somalia, the two bits that we have entered into force, both of the bilateral investment treaties were provided by the other state parties, which were Egypt and Germany at the time. I don't think there was any negotiation that happened from Somalia's side. And so, yes, looking back, so much should have happened, I think, in terms of development and reform. But sometimes, and in my experience as a diplomat, it is much easier for states to go with the familiar and for them to go with something that is sort of tried and tested and they know and that they see as, as more transparent, which in this case, I think means them including ISDS in their bilateral investment treaties, because there are alternatives. One interesting thing that I noticed looking at, for example, Morocco and Rwanda's 2016, I think it was bilateral investment treaty, there was no alternative to arbitration. And so if I remember correctly, there was ICSID listed there, which surprised me because I think we're at the point now where, again, there's been so much discourse and there's been so much discussion. And when I did speak to my Rwandan counterparts, they did say that there was heavy involvement from the private sector, sort of pushing towards this, again, going with the familiar of what they already knew, and them saying that there hadn't been much discussion around alternatives. So I think within us as African members, you would think that there would be a development. I think even within intra-Africa, development of ISDS and alternatives to investment arbitration, but there hasn't been so much. If we look at the AFCFTA right now, there isn't any provision, I believe, for private parties to bring any claims through the dispute settlement mechanism. And they've basically used the same template as the WTO, which was interesting. And for me, that I don't want to say I was surprised by that. Yes, the WTO, is a huge body, and but the WTO itself is under huge scrutiny for reform, right? So if the WTO itself is under, and this is public, everybody knows this, even if you're not a trade person, everybody knows that the WTO has been under a lot of scrutiny recently. So the fact that the AFCFTA is pretty much following the same WTO template for dispute settlement is quite surprising. So there has to be, I think, looking at African states, some sympathy, I think, to the history of what they've already sort of used, the uneven playing field when it comes to negotiating their agreements with other developed states. And that happens to be, you know, the case now with more discussions around, you know, Africa is open for business and the Belt and Road Initiative, as we can see with China and some of the bits that they've signed with African states, third generation bilateral investment treaties. And so there has to be, I think, more imagination and more creativity for us to be able to move towards maybe potentially other alternatives to investment arbitration, and provide those things that African members can actually have, again, alternatives to actually signing the same sort of bilateral investment treaties that they are provided, and even with themselves as intra-Africa treaties continue to rise and be signed.
Thank you so much, Maryan. I'm aware that there's a lot of discussion in that area, and hopefully, if we have time, I'll tease out a couple of points based on what you've said. But let's move on for now, depending on how much time we have. Picking up on what you said, let me ask you a question, Jackwell. So a number of years ago, South Africa decided to terminate a number of BITs. Very quickly, in about 2 to 3 minutes, what was the background to this decision? And I'm aware that around that time, South Africa introduced a new act. I think it's called the Protection of Investment Act or something like that. Are there any key, interesting provisions in the act that you would want to draw to attention in about 3 minutes, if possible, 3 to 4 minutes?
I'll try. It's difficult, but I'll try. So South Africa took a policy decision. I think it's now almost 10 years back, to essentially allow certain BITs to lapse or terminate, depends on how you view it, and also to then adopt domestic piece of legislation called the Protection of Investment Act to essentially regulate, provide protection, more domestic protection for investment in the country, and to level, as the Act says, level the playing field between foreign investors and domestic investors and give them the same rights and recourse. Now, the policy decision was essentially triggered by a case called Posteri. It didn't go very far, but in that case, Italian investors challenged the South African state to the additional facility of ICSID on a piece of legislation that was enacted in 2006, which is the Mineral Petroleum Resources Development Act, where that act essentially wanted to ensure that there is economic transformation, black economic transformation, having regard to the context and history of South Africa, to ensure that more black people benefit from the natural resources in South Africa. And by virtue of that legislation, a policy decision that was taken by the South African state, a legitimate constitutional policy decision, to transform the economy of South Africa, was challenged by foreign investors, saying that you want us to essentially give up a certain percentage of our shareholding in the company to South Africans. So that, and another case, which is the Swiss case, where also South African, it's not in the public domain, but the South African state was challenged on an issue of full protection of security, which is also another standard of protection you would find under treaties, where it was alleged that the South African state did not give the Swiss investor sufficient protection for invasions and damage to his farm. So that's the policy decision behind it. And I know, again, it doesn't do it justice because there's a lot of other things. So just jumping from that, terminating some of the BITs or allowing some of them to lapse, and then ultimately adopting a domestic piece of legislation, looking at what is the what is the silver lining, maybe, if we can call it that, in the domestic use of legislation? Obviously, it's domestic laws can be changed at any time, and it doesn't really provide real protection for any investor because of that. But what it does do is, in the current act, it creates this concept, as I mentioned earlier, about fair administrative treatment. That concept has now been adopted from a regional perspective, and I've also noticed in actually a recent treaty that was concluded between, I think it's Ethiopia and Qatar, it actually includes that standard. So it seems it's finding its feet in international law. Obviously, it's a debatable standard because of also what it ultimately entails. The other part is probably the endorsement by the South African state and government of mediation. Saying, you look at the act, there's a big endorsement of, if you want to resolve a dispute with the state, you don't have to do it through an adversarial process. You can use mediation. There's a whole process in terms of the act, and there's rules that have been adopted that you can submit to our Department of Trade and Industry if you have a dispute with the state. Whether that's sufficient, again, for an investor doing an assessment of the state and the risk is another question. That's, again, very briefly, but there's so much more to talk about.
Thank you so much.
Okay.
I think what you've done is you've been able to throw out enough issues for people to go on and do a bit of further research, which is very good. Thank you so much. I think in order to throw out a couple of other issues for people to go on and do further research, I'll go over to you, Guled. And my question is, what are the recent developments in the field of ISDS? And are there any particular lessons that you would want to draw out for African practitioners? So are there any recent developments, any trends that you think we should be looking out for at the moment?
Yeah, I mean, I think one big element is the reform process that's taking place at present. So before, when there were a lot of concerns raised around ISDS, those were raised by states in Central and South America in particular, and the approach taken in those instances was to retreat from the system. So to denounce the ICSID convention, to leave ICSID, to not participate in the system any further. There have been other efforts as well to sort of distance states. So South Africa is a good example where the focus was really on ensuring that the settlement of any investment disputes took place domestically. And recently we've seen many more investment treaty disputes being brought against European states and North American states, but primarily European states. So Spain in particular has had many claims brought against it. And so there's been a concern raised in sort of the public eye in Europe and in North America about ISDS. And you've seen many recent presidential candidates such as Elizabeth Warren and Bernie Sanders discussing these issues in quite a bit of detail. And the latest sort of US-Mexico-Canadian trade agreement, which replaced NAFTA, has reduced the scope for investment arbitration as well. But the approach in Europe has really been to reform the system internally through a multilateral system rather than pulling out completely. And although there have been concerns in Africa, I think Africa should really play a key role in that reform process and really ensure that sort of it's properly represented in that process and the future of investor-state dispute settlement. And I think one good example of that is the issue around the arbitrators that are appointed. So actually being thought leaders in terms of issues like double hatting, where people act as counsel and arbitrators, also playing an active role in ensuring that African nationals are represented in tribunals, because it's one of the most underrepresented regions amongst tribunals at ICSID, for example. And if you look at the sources of appointments of African nationals, split it between the parties appointing their respective arbitrators, and then ICSID appointing arbitrators in instances where a party has not appointed someone, or during annulment proceedings where ICSID has to appoint someone, you'll actually find that ICSID does a much better job of appointing African nationals, of appointing women than the parties to the disputes do. And so I think African practitioners can play a role in that. African states can ensure that they update their list of nationals appointed to the ICSID panel more often, that they participate actively as thought leaders really in the ICSID reform process, in the UNCITRAL reform process, because this is a critical time for investor-state dispute settlement. And a lot of issues around transparency really will determine the future. Transparency, efficiency, consistency will determine the future of investor-state dispute settlement. And given all the experience that African states have with the system, as Leah mentioned, I think it's important that they play a role in many of those issues. It's really a critical period.
Thank you so much, Guled. I can see a number of people have already sent in questions. But before we go into the question and answer session, you guys are shining lights in Africa, and you're just making us proud. And I want you guys to comment and give tips to participants, especially in relation to your different areas. So you all have different paths. And I would start with you, Leah. Before you joined ICSID, you worked in an African law firm in Kenya. Do you have any special tips for Africans looking, to join an international organization like ICSID? I'm sure there are many people who want to, join and work at, a leading organization like you. What are some of the tips that you give them? 2, 3 tips in about 2 minutes, if possible.
Right. Thank you so much for that question. And I usually get asked that a lot. And I think what I would say at the top of my list is that you need to position yourself for a career in international arbitration. Like, you need to get what I would say the base standards. Like, for example, for you to join ICSID, you would need a postgraduate degree in law. And I'm saying that not to close out, what the students and other people, if you don't have that degree, I think what it is that is the standard, and we should only aim higher. So I'm just saying, aim for a higher degree wherever you are right now. Just aim for a higher degree. And I think for me, that really played a big role in me joining ICSID. So the other thing I'd want to talk about is that you also need exposure, because that postgraduate degree or that higher degree that you're pursuing will give you exposure into the international arbitration field. And I think it's putting aside the issue of a postgraduate degree, there are also other ways in which you can, sort of put your foot in. And one of them is also participating in an educational program. You have your moots. You also can pursue an opportunity to, deepen your knowledge in arbitration. There are very many summer courses going out there. I know Young ICA also have a platform for scholarships. If you need a scholarship to attend one of the institutions that offer international arbitration as a focused master's degree program, you could do that. I think just, putting yourself in a place where someone can actually look at your CV and say, this is a person that we've been looking for. Another very small tip I would say is that I think my experience at J. Miles & Co., which purely focused on international arbitration, really boosted my chances of joining ICSID. And I would just say that working as counsel was, I think, key in doing this move, making this career move. And also, if you're not able to get a place where you can get experience in international arbitration, particularly in Africa, I know the spaces are thin and, there's not many people doing this. All I want to say is that you can find someone who you can shadow. You can look for secondment opportunities. I know ILFA, that's the International Lawyers for Africa, have a program that can do that. And there's so many avenues at this moment that we didn't have, like, let's say 10 years back, 5 years back. So this field is rapidly catching up in the African sphere. I mean, the very fact that you have all of us here as Africans, is testament to that you will, there are opportunities for you as an African. Then just lastly, internship, like look for those internship opportunities. Quite recently, we had we had someone joining us at the Washington, D.C. office from Casablanca, and he moved mountains to join us at ICSID. So I'm saying that if you really want to pursue a career in international arbitration, you really need to put yourself in a position where you can work in an international arbitration, firm or institution. Yeah.
Indeed. Those are very, very useful tips. Tips that I've also used in the course of my career. I'm sure someone out there is thinking that not everyone can afford a master's.
Yeah.
I mean, if you can't afford a master's, there are courses, there are conferences like this that are free of charge for you to be able to learn, sophisticated areas of the law. I mean, we're discussing ISDS, so please take advantage of things like that. Another way that you can also project yourself is, writing papers. It's a free opportunity for you to, project the amount of knowledge that you have. Write articles. Look for good platforms. Clue, PLC. These platforms would publish your article free of charge, as long as it is good. So yes, please take advantage of such opportunities. Guled, let me go over to you. One question that people usually ask me is, what qualities international law firms look out for when looking to work with local counsel in international arbitration. You are a lawyer at one of the leading law firms in the world, and a senior lawyer for that matter. You're counsel, you're virtually a partner. Do you have any wise words for young lawyers looking to get on your radar, lawyers who are building their practice? What are the kind of things that you think they should start to do in order to, work with, someone like you?
Yeah, no, absolutely. I mean, I think there are a number of things to keep in mind. One of them, I think, as a general matter, is sort of profile raising. So there is a tendency for law firms to look for local counsel by looking at local legal directories. So, looking at Legal 500 in the relevant jurisdiction, chambers, that's often a starting point. Internally, we also have a list of local counsel that we have relationships with. And so I think it's fostering relationships with large international law firms that will be able to instruct local counsel is a critical element as well. So I think those are some very important means of doing that, of developing firm-to-firm relationships, developing your firm's profile, your profile as an individual. And then I think the last element in that is really developing your own profile through, as you mentioned, Ademola, publications, talks, conferences, things along those lines, I know Maryan and Ademola for some time now, and to embarrass them a little bit, I think they're both incredible self-starters and have developed a very wide network in the arbitration field. And they've done that by being sort of their own persons rather than specifically being and have their own individual profile. And I think that's absolutely critical in this field, especially where we don't have sort of repeat clients in a sense as much in dispute resolution in the same way that you do in transactional departments. So it's much more focused on practice groups or individuals when you're looking for people to collaborate with or work with. And then obviously, it doesn't all turn purely on relationships. There has to be the substance as well. And it's just the technical ability, being on top of legal trends. There is a tendency, I think, sometimes to involve local counsel in matters where they're only given a small snapshot of a transaction or a dispute. And that can be quite difficult because you might be given a few questions to answer. And I think it's very important in those instances to issue spot and ask about the wider implications of the transaction itself in a far broader scope. So I think those are broadly the two things that I would keep in mind, the sort of profile raising and relationship building, and then also just the technical abilities and being responsive, being thorough, thinking carefully about the context in which you've been asked your question, and so on. And I think these things can vary, right? So, Ademola, we're based in London, so we have different opportunities to build our profiles, right? And in different ways. We can focus purely on arbitration in a sense. But if you're at a firm in Nigeria and you're really trying to raise your profile as local counsel for international firms like Hogan Lovells or A&O, there are fewer opportunities to focus purely on arbitration, but I think that you need to really develop skills across a wide swath of work, whether it's general disputes, litigation, energy, etc. And then when the opportunities arise to focus more on arbitration, I would seize those over time. I think there's a lot of pressure people put on themselves nowadays with this view that, to be an arbitration lawyer, you have to do only arbitration, which is not the case. This is a fairly new field in the sense that, 20 years ago, there weren't really many, if any, purely arbitration practice groups where people did nothing but arbitration. So I wouldn't get too obsessive about that. But those are just a few things to keep in mind. It's a lot of the same requirements that we have as practitioners in London, that local counsel have to keep in mind. But I think for local counsel, there's a very good opportunity to stand up in a local jurisdiction as somebody that international law firms go to.
Thank you so much. I chuckled when you made reference to the pressure to do, just arbitration work. And I think one thing many times we forget is that ultimately arbitration revolves around substantive areas of law. And so knowledge gotten in other areas of law, other practices would also be useful in the course of your practice. So yes, while you're waiting for that big arbitration brief, take advantage of the opportunities to learn other areas of the law because they would ultimately be useful in the long run. Thank you so much, Guled. Maryan, you've done well for yourself. In addition to your work with the government, I'm aware that you were also the youngest lady to be appointed on the ICSID panel. I actually think, Guled, you were also the youngest man to be appointed on the panel. Correct me if I'm wrong, but we're talking about Maryan now. Do you have any tips for any young African who wants to sit on panels like ICSID? What are the kind of things you would advise them, or what are the kind of things they should start to have in mind?
Okay, thank you. And by the way, Guled is outstanding, but he's too humble. So he will never share his achievements with anybody, including this. Like, no one knows he's on ICSID, because he's an outstanding individual, No, so the advice that I would give I think it's about taking risks. At the time, I was in Dubai and I was working with an international law firm called Al Tamimi and Company, and I was dealing with, I think, purely commercial arbitration, and specifically moving into the usual Middle Eastern route of being pigeonholed into construction arbitration. And I was doing some work for the Somali government on the side, and I just really, really enjoyed it. And it's exactly like Guled said, you don't have to just only focus on arbitration. So how I started helping the government was I worked on a landmark MOU. There were Somali fishermen that so a lot of them were wrongly detained and imprisoned in India on pirating charges. I think 2 of them died because the conditions are so squalid. I had absolutely no idea what I was doing. But we put together this MOU, kept negotiating with the Indian government, and eventually, I think over a year or so, we were able to get a lot of the young men back in Somalia. And so whilst I was doing that, I started working with the Attorney General, and they had offered me at the time a contract with the UN. And I took a risk. Everyone thought I was crazy because at the time, Somalia had just transitioned out of a civil war. It was, of course, very volatile and very fragile at the time. But I could see the potential because I was working with an administration that I think at the time understood the importance of the rule of law. I then moved into working with the Prime Minister, and interestingly, the Prime Minister at the time, his father was the one who, when he was president in the 1960s, was the one who ratified the ICSID Convention. So he was someone who really understood the importance of arbitration. And I was very, very fortunate, I think, to have my start with people who not only understood, but even if they didn't understand, kind of allowed me to bring in experts around the world, such as Gary Bourne, such as Guled. I had a lot of amazing people help me draft legislation and do a lot of work for the Somali government and sort of experiment at the same time. Because I don't like the term, you fake it till you make it, but you're pretty much winging it because it's, it's a state and it's a country that's come out of civil war and their needs are different. And I think, my, I guess, leadership and, the fact that I was very resilient and that I was very, very dedicated and committed to my country did help me. And so I don't, for the Attorney General at the time, he wasn't looking at whether I was the youngest woman or anything. He was obviously in discussions with Meknir because there was the ICSID rules amendment that were about to start, and Somalia has been heavily involved in that. And so I think for my government at the time, they sort of factored in everything that the team and I had done. And my advice to young practitioners, because I think everybody is so desperate to get into international law firms, please remember, and I'm sure, you know, Leah, Guled, everyone's had international organizational some type of governmental experience, right? While studying or otherwise. It's really, really important that you can take advantage of maybe your local embassy. So if you're in, you know, New York, your UN mission, your country's UN mission, in London, you know, because they always have need most of the time for an extra pair of hands, a legal intern or a legal officer or something that you could do while you're studying, and you could, you know, work, I guess, maybe 1 day a week or something, you know, because at the end of the day, it is very expensive to travel and do an internship somewhere else, but you could make the best use of what you have right there. And I think it will also give you an added edge because you're looking at governmental issues, you're looking at bilateral, multilateral issues as well. So I think there is so much to do when it comes to working with the government, and it's exceptionally exciting. And I had such a great time working for the federal government of Somalia. So I advise anyone who wants to try and work for government. Okay, yes, the pay isn't as great as international law firms, but the experience of helping your country is very enriching. Thank you.
Thank you so much, Miriam. Yeah, I don't know about that being the pay not being as good as international law firms, but we'll leave that. I know that not everyone wants to work abroad, and so there are people who, you know, are very patriotic and want to stay in Nigeria and stay in Africa. And so my next question would be for you, Jackwell. You are a director, a partner at a leading law firm in Africa. Do you have any tips for any young African looking to build a successful practice in Africa in 2-3 minutes?
Okay. Yeah. So the first statement, I think it's important that African practitioners and lawyers start staying in Africa, building capacity to ensure that that African law firms can take on whatever cases, whether it's an investor state arbitration, whether it's a big commercial dispute. So it's important to start building capacity on the continent. Not that there is not capacity, but we need to expand the capacity. So Cliff Decker Hofmeyr is one of the largest South African-based law firms. So we have 120 partners, and we have about almost 400 or 500 lawyers in total. So with a firm like that, so from a capacity, so we have a big dispute resolution department that services all types of disputes, which is arbitration, mediation, and court litigation. Now, my practice and how my story essentially evolves is that I have done dispute resolution work, but also advisory work for whether government, state-owned companies, or private sector companies, mostly in the mining and energy sector. And through those, with the transactional work, ultimately there's an arbitration clause and there's an arbitration. So building your skills and capacity as African arbitrations through domestic arbitration. And those arbitrations are not necessarily small arbitrations. Most of the arbitrations that I've been involved in, although it might be domestic companies, runs into the billions of rands and even dollars. So, and it is complex issues. So it's important not to discount African law firms. Ensure you build capacity through, you apply to African law firms if you have the ability to do that. Build your skills and capacity there. In practice, the practice is very ruthless. It's a rude awakening from being in university and ultimately going into a law firm where what you have been taught and what you ultimately need to do in practice is usually fundamentally different. But when you get there, when you're not in arbitration practice, you'll do rudimentary work. You are a trainee attorney, so be prepared to learn, be prepared to be there, put in the effort and time, and you will definitely then get exposed also in building the soft skills and also the legal technical skills to ultimately be a good practitioner. So my advice is that put in the time and effort, people will notice you. Stay in Africa, contribute to the development of Africa and Africa's contribution to international commercial and investment arbitration, because we need those practitioners here. We don't want them in London. We don't want them in New York. We want them here.
I'm surprised that you would say so. You don't want me to eat, Jackwell.
I want you to eat. I want you to eat here.
Thank you so much for that. Indeed. Someone mentioned, the influx of investment into Africa, and whether we like it or not, there's really going to be that need for African law firms to, take up some of this work and step up. And so the opportunities exist within the continent for people to actually thrive and succeed. So thank you very much for that. Now, we have a couple of questions which I've seen come through, and I would ask them randomly, and hopefully I'll see people sweat now. My first question is for you, Leah. We're seeing an increase in interest in mediation. And someone wants to know, is there a real potential for mediation in ISDS? Especially, ISDS generally. So there's the reference to the Singapore Convention, which, is a recent development. But are we able to also, make use of mediation in ISDS involving African states? Over to you, Leah.
Yes, an overwhelming yes is my answer. And the reason I say this is because there is, there's a shift, alluding to what Maryan just said. There's a shift to try and look for alternative methods of arbitration, not necessarily the adversarial process that we always see at ICSID. So there is a shift in looking for those alternatives, and we have several BITs actually that have incorporated mediation as a pre-action method or mechanism for solving disputes. So we have the Morocco Mali BIT of 2016. There is also a Canada and Burkina Faso BIT that references mediation. And there is, of course, the Singapore Convention, which we've just mentioned. And a number of states, I think, are signatories. I think right now we're at 45. And so there is a real potential for mediation in ISDS involving African states. And we also have the Pan-African Investment Code, and that specifically does mention mediation. So I would say that yes, there is an overwhelming space created for mediation involving African states, and ICSID statistics do support this assertion that I'm making right now. I just said, I started my presentation a few minutes ago by saying that Africans were heavily involved in developing the ICSID Convention and ICSID practice as a whole. So going by what our statistics are telling us right now, 41% of proceedings involving African countries have been terminated before final decision by a tribunal. And you can compare this to around 34% for all ICSID cases. So you see there is a potential for having some type of alternative mechanism for resolution. Of this 41 proceedings, 41% of the proceedings, 60% of them have been terminated at the request of both parties. And this is compared to 47% of all ICSID cases. So, some people may look at this and say, yes, African states appear to be more prone to settling disputes through negotiation than countries from other regions. I don't know if this has to do with our traditional background as Africans of talking through things rather than going to court. But I think that this is a good indication that there is space for African countries to carve out a space for mediation. And this is actually really supported by what we're trying to do at ICSID with our rule amendment project. We've actually developed and we are proposing new mediation rules. At the moment, there is no separate mediation rules in our rule framework. So we're proposing, and we've done so in our past working papers, 4 working papers, we propose these rules. Of course, they are still under development right now, but I think yes, there is space to carve out this mediation sphere. Yeah.
Thank you so much, Leah. So I have an interesting question here, and I think the question arises from a situation that was in the press a couple of months ago, and I think I would address that to Guled. Someone is asking, do we see sovereignty immunity, so sovereign immunity clauses very regularly in international commercial contracts? And basically, the person also wants to know what the legal implication is of a sovereign immunity clause in a contract. In about 2-3 minutes, is that possible to do that?
Sure. So, I mean, just taking a step back, as a general matter, sovereign immunity just means that you cannot bring legal proceedings against a state without its consent, that you cannot enforce any legal decision, whether it's a judgment or an award against the state's assets, for example. So those are the two broad categories of immunity we have in mind. Originally, state immunity was absolute, really. You couldn't bring claims against states, and that's a very traditional view. But things have eased up, and there have been several exceptions. So, instances where a state is acting in a commercial capacity or enforcing against states' commercial assets as opposed to sort of sovereign assets have been carved out as exceptions through legislation. So there has been an evolution on that, and there are more instances now where states have claims brought against them in domestic jurisdictions and have enforcement against their assets. So I know that those rules are governed through statutes, legislation in the UK and in the US. I don't believe Nigeria has a statute on that, so it's more by practice and specific consent. And we advise our colleagues in transactional departments quite often on agreements that our clients enter into with states or with international organizations. And we consider it imperative that they do get a waiver of immunity for the purpose of that specific transaction. Otherwise, you have no recourse. So you can enter into an agreement where you provide goods to a state or international organization. If they don't comply with their obligations, you won't be able to take them to court. You won't be able to commence arbitration. And even if you can, then you might have a Pyrrhic victory where you get a decision on paper, but you can't enforce it against anything. So it's become very common practice in commercial dealings with states and international organizations. And we've seen states and international organizations play a much larger commercial role nowadays. So I guess the final point is really that I think what you're hinting at is the fact that Nigeria signed a loan agreement with China for investment into IT infrastructure and a rail construction contract for the Export-Import Bank of China in 2018. Both contracts contained a waiver of sovereign immunity clause by which Nigeria ceded its enforcement immunity, meaning that claims could be brought against Nigeria, and those claims, if successful, could be enforced against Nigerian state assets. And I believe that it was reported in the press in Nigeria that there was sort of a general ceding of sovereignty, which is not the case at all. It's just there was a waiver of sovereign immunity for this specific purpose. And really that waiver of immunity ultimately is an act of sovereignty itself. It is specifically consenting to enter into legal proceedings and have enforcement against your assets. But to be clear, there are limits. You can't enforce, for example, against a country's embassies. You can't enforce against its tanks, etc. There are barriers to that, but there have to be certain exceptions in order for states and international organizations to transact in the modern world.
Fantastic, thank you so much. So there are limits to the application of sovereign immunity, and we should not be worried that one day we would find out that our country has been taken over. Thank you so much.
Yeah, I think there are some important considerations for states, obviously, and to make sure that they negotiate things very carefully. There's obviously the example of Sri Lanka, where they entered into agreements with China to provide a number of loans for the purpose of a port, and ultimately following defaults and non-payment, there was a provision, I think, in those agreements which allowed China to have a lease over a port for 99 years or so. So things like that are very, people are very cautious about that. Slightly different from the notion of waiving sovereign immunity. Those are the terms and conditions of any agreements entered into by states that states have to be very rigorous about.
Thank you so much for that. I have a question, and I think I would address this to you, Maryan, and that's because of your previous experience. and it's, let me read it. What are your thoughts on ISDS for the least developed and conflict affected states? I suspect this is for you, considering your Somalia's background, but could you want to comment on that?
Yes, it's interesting because when we speak in the African context, I think even amongst Africans, they can forget Nigeria, for example, they can forget that, especially when I'm dealing with other delegates from other countries, that, we are all at different economic levels, and we are all at, different levels in terms of stability, right? And sometimes, even within the African context, a sort of a one-size-fits-all approach doesn't work, right? So when I was in Somalia, I had to even myself sort of address my own ignorance when it came to ISDS and what works. Because you are dealing with a country that has pretty much lost most of its documents and has had total state collapse in most instances, or you had countries that were sort of very robust and strong, such as Libya's case, and then are now, they've fallen into conflict, and they're still having to deal with multiple ongoing disputes as well. So it's you can be at either ends of the spectrum. Some takeaways I think from my time in Somalia is to never underestimate how disruptive government changes can be. If you are dealing with a government change, and especially a cabinet reshuffle, you can have a certain government, you can have allies in that government. And it's really important that you do have like your attorney general and certain ministers, because you won't be able to move anything without those people when it comes to obviously legislation, going through to the cabinet, going to parliament for first reading, just even general support in terms of the private sector, because you see, I guess, the private sector and the public sector, but one cannot exist without the other, right? And so the government can also help when it comes to the private sector. In terms of post-conflict and conflict-affected countries, the traders, in terms of Somalia's case, the private sector was king for a long time because there was no government, and the private sector was still going strong. And you have to find ways to engage the private sector and to get them to understand ISDS, to also have their feedback and for them to understand, because I say this every time, most of the time when I speak, like the president of the Chamber of Commerce at the time, I remember when I sat with him and we were going to have the first Somali International Arbitration Summit, and he was telling me about all types of like non-conforming shipments that he'd have from China. And like one shipment that he had was a whole container of left feet. Like the shoes were all left foot shoes. There were like no pairs of shoes. And, he was just like, what can I do in that case? Can arbitration help me? And then we sort of explained to him, and now he has like clauses in his agreements and, arbitration clauses. And it was baffling to me, because this is, someone who's a huge person in terms of the private sector. And so we were able to slowly bring the private sector around. I think when you look at ISDS, you can't get there without first talking about commercial. I think on the domestic setting, you've kind of really need to deal with the commercial side. And then obviously at the government level and the policy level, you can really discuss ISDS. And finally, I think it's probably even worse for these countries when it comes to local council, because a lot of people have fled from the war, right? So there's brain drain. A lot of people are in the diaspora. And so it's much more convenient for them to just pick up counsel from like random countries in Europe and in America, cities in America. And that is really, really difficult, because you're dealing with people who not only don't understand the socioeconomic status of your country, but they don't understand how to even deal with, people who are traumatized, right? Often government officials, because of what they've gone through in the war, and understanding that sort of cultural dialect that you need to be able to speak to officials when it comes to, when you're dealing with discovery and different stages of a case. So I think it's important to not understate the social aspect, the cultural aspect, and also to be mindful of the private sector as well as the government perspective, and also again be mindful of government changes and disruptions there, because it does happen.
Fantastic. Thank you so much. I can see we have too many questions, but I think we have the opportunity to ask one more question, and I would address that to you, Jackwell. There's a question here on the difference between ISDS and state-to-state international arbitration. I think you're best placed, because I believe that one of the implications of South Africa's termination of BITs was that South Africa was no longer bound by ISDS. Correct me if I'm wrong, bro. Please, just in 1 minute, 1.5 minutes.
So state-to-state arbitration, in simple terms, is essentially one state initiating a claim against another state, but in the context of an investment claim would be what we will call an espousal claim, where the investor, and more so in the Custom International, will approach the others, would approach his host state saying, South Africa infringe on my rights, this is what they've done. So again, a discretionary decision of the state to initiate the state-to-state arbitration against the other state. And in most instances, because it's a political decision, it never happens. So the South African Protection of Investment Arbitration Act contemplates that it says the South African government may, and again, consent, because the consent is a golden thread in arbitration, may consent to a state-to-state arbitration. So it is open, but the other option for an investor is through the Custom International Law process of an espousal claim, if that. So that's in a nutshell in 1 minute again.
Thank you so much. We've run out of time, and I must confess that it's been a brilliant session. Panelists managed not to break a sweat, and I must thank you so much for taking out the time to answer questions. I know it's a busy time for every one of us, and so thank you so much for taking out the time, and thank you to the participants too for your many questions and for being very engaging. Over to the YMG team.
Good afternoon, everyone. We have come to the end of the YMG, the 4th YMG annual conference and the first ever virtual YMG conference of the Chartered Institute of Arbitrators UK Nigerian branch. On behalf of the YMG of the Chartered Institute of Arbitrators UK Nigerian branch, we would like to sincerely appreciate everyone that has directly and indirectly contributed to the success of this conference. Our deep sense of appreciation goes to all our amiable speakers who have enlightened us with their in-depth knowledge and excellent coverage of the various topics on the theme, The New Frontier, the Position of Young Arbitrators. It is worth noting, flowing from the discussions of the various speakers, that this theme reflects new opportunities in Nigeria and indeed globally. As young arbitrators, with the acquisition of relevant skills and ability to grasp technology quickly, we are well positioned to take advantage of these new avenues to effectively grow our arbitration careers. Being young has never been this good, with the learning, training, and even the mentorship at our disposal. This conference has exposed us to the various opportunities encapsulated in the virtual world, while keeping us abreast with various arbitration laws. All the speakers were carefully selected because of their considerable strength in terms of knowledge on the topics allocated to them. In conclusion, we hope that the topics, the knowledge shared, and network gained during this conference would prove to be advantageous to every young arbitrator. This is not conference as usual, as we hope it will leave a lasting impact on young arbitrators while giving us the opportunity to strategically be placed in relevant positions to take up the mantle of actually practicing and earning from arbitration. Finally, we sincerely appreciate all the kind gestures the YMG got from the CPC chairman and even the team as a whole. Please join us tomorrow by 9 a.m. on the Woover app, on the YouTube channel, CIHAB 2020 conference. Enjoy the rest of the 2021 ever conference of the Institute. Thank you.
Thank you so much to